This indictment was filed on March 15th of 2024. Each of the 4 counts is a violation of 2925.11a, count 1 being possession of cocaine, an F5, count 2 being possession of fentanyl, an F4, count 3 being aggravated possession of drugs, an F5, and finally possession of heroin, felony of the 4th degree, that being count 4. Discovery was sent a long time ago. The second case, Your Honor, is case number 24 CR 896. This one is out of Willoughby. The indictment was for 3 counts, which was filed on September 3rd of 24. Discovery has been sent. Each of these is a violation also of 2925.11a. Each is an F5. Count 1 would be possession of fentanyl. Count 2, possession of cocaine. Count 3, aggravated possession. Each of these carries a forfeiture specification, Your Honor. With regard to both cases, we expect the defendant will plead to each of the indictments, Your Honor. There is no agreement as to sentencing. Thank you.
All right, Mr. Nelson.
Thank you, Your Honor. The prosecutor is correct. At this time, my client would like to withdraw her formally entered plea of not guilty in both cases and enter pleas of guilty to the indictments. I've had a chance to review the plea sheets with her. She understands that. I believe it's a knowing, voluntary, and intelligent plea.
All right, Ms. Arnold, how old are you?
30 years old,
How far did you go through school?
all the way in high school.
Are you a
Graduated
U.S.
from-
citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed with?
Anxiety, PTSD, bipolar, depression.
And are you being treated currently?
Yes.
Do you take any prescription medication?
Not at the moment, but I was when I was in the facility that I was in.
All right, did you get a copy of both indictments in these cases?
Yes.
And you're pleading guilty to all the charges in each indictment, is that correct?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you some questions. If you don't understand a question or you want to talk some more to Mr. Nelson, let me know, and I'll give you more time. You understand that?
Yes.
All right, you have in each case, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
I understand it.
Are you waiving that right to the jury trial?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
After the, if you go to trial, the prosecutor is going to call witnesses to testify against you. Do you understand he must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you
Yes.
understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings that take place in this case. Do you understand that?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Now, in the 23-1194 case, count 1, possession of cocaine is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Count 2, possession of fentanyl-related compound is a felony 4. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
In count 3, aggravated possession of drugs is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Count 4, possession of heroin is a felony 4 with a 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
All right, now, I could give you a consecutive prison sentence in this case. That means one sentence after another for the separate counts. If I did that, you face a 60-month maximum prison sentence and a $15,000 maximum fine. Do you understand that?
Yes.
In case 24-896, count 1, possession of a fentanyl-related compound is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Count 2, possession of cocaine is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
And count 3, possession of a dangerous drug is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
And if I gave you a consecutive prison sentence on that case for the separate counts, you face a 36-month maximum prison sentence and a $7,500 maximum fine. Do you understand that?
Yes.
Go ahead, Mr. Funchi.
I just wanted to point out, I believe I made a mistake on count 3 of the
Okay.
2024 case. I believe I called it aggravated possession of drugs, and I may have done that also on the paperwork, Your Honor, when it should be possession of dangerous drugs.
Okay.
I apologize.
All right, so it is possession of dangerous drug, okay. All right, now, I could give you a consecutive sentence on these cases, one after the other. If I did that, then the total between the two cases would be a maximum prison sentence of 96 months and a maximum fine of $22,500. Do you understand that?
Yes.
And if you plead guilty to the forfeiture specification, you're voluntarily giving up the items listed in the specification. Do you understand that?
Yes.
All right, you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
Yes.
You understand your felony conviction prevents you from owning or possessing a firearm.
Yes.
Do you understand that if a prison term is imposed in this case, that you might have to serve a period of post-release control as part of your sentence after you're released from prison for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yeah.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions between these two cases, I could send you to prison for 96 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
You understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes.
Have you had enough time to talk to Mr. Nelson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Mr. Tavanche, with regard to 23-1194, if that case went to trial, what would the evidence show?
Yes, Your Honor, the evidence would show that on, excuse me, October 22nd of 2023, East Lake PD came upon a suspicious vehicle parked at the gas station. This was in Lake County, Ohio. Defendant was behind the wheel, apparently unconscious. Officers saw suspicious substances in plain view. The Lake County Crime Lab confirmed that at least one of those substances was fentanyl, a Schedule II substance, another cocaine, a Schedule II substance, another methamphetamine, Schedule II, and heroin, a Schedule I substance. That is all.
All right, Mr. Nelson, anything to add to those facts?
No, Your Honor.
Ms. Arnold, did you hear what Mr. Tavanche said the facts would show if that case went to trial?
Yes,
And are those facts true?
yes,
All right, what is your plea then to count 1, possession of cocaine, a felony 5?
guilty,
What is your plea to that forfeiture specification?
guilty,
What is your plea to count 2, possession of a fentanyl-related compound?
guilty,
What is your plea to count 3, aggravated possession of drugs, a felony 5?
guilty,
And what is your plea to count 4, possession of heroin, a felony 5?
guilty.
All right, Mr. Tavanche, if 24-896 went to trial, what would that evidence show?
The state would show that on July 11th of 2024, Willoughby PD responded to a call about a suspicious vehicle that was parked at a trailer park. This was in Lake County, Ohio. The defendant was found in the rear of the seat of the vehicle, found to have an open warrant. Search of her purse yielded suspicious substances that the Lake County Crime Lab later determined that at least one of those was cocaine, a Schedule II substance, another fentanyl, a Schedule II substance, and another search for lean, a dangerous drug. Defendant was previously convicted of a drug abuse offense, Your Honor. That is all. Thank you.
Mr. Nelson, anything to add to those facts?
No, Your Honor.
Ms. Arnold, did you hear what Mr. Tavanche said the facts would show if that case went to trial?
Yes,
And are those facts true?
yes,
What is your plea to count 1, possession of a fentanyl-related compound, a felony 5?
guilty,
What is your plea to the forfeiture specification?
guilty,
What is your plea to count 2, possession of cocaine, a felony 5?
guilty,
And what is your plea to count 3, possession of dangerous drugs, a felony 5?
guilty.
Mr. Nelson? Mr. Nelson, here.
Oh, I'm sorry, Judge. Do you want her to execute the plea sheets,
Yeah.
Judge? We just have to sign it from the court. Just sign. As good as you can. Sorry. Today is 3/24/25. And this is the second case. Same thing. Yeah. I thought my handwriting was bad.
Your Honor, I have witnessed the defendant and counsel sign the plea documents. My signature is there on both of them as well. Approaching.
All right, Ms. Arnold, on each of these written pleas of guilty, is that your signature contained?
Yes,
And did you sign each of them voluntarily?
yes,
And on each case, do you want me to accept your written plea of guilty?
yes,
All right, on each case, I will accept the written plea of guilty. Defendant was present when Mr. Nelson advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, consequence of her guilty plea, and the maximum penalty, finding them to be knowing, intelligent, and voluntary. I will accept her plea of guilty on 23-1194 and find her guilty of count 1, possession of cocaine, a felony 5, and the specification. Count 2, possession of a fentanyl-related compound, a felony 4. Count 3, possession of drugs, a felony 5. And count 4, possession of heroin, a felony 4. On 24-896, I will accept her plea and find her guilty of possession of fentanyl, count 1, a felony 5, and the specification. Count 2, possession of cocaine, a felony 5. Count 3, possession of drugs, a felony 5. And refer each case to the probation department for a pre-sentence report and drug and alcohol evaluation. Sentencing in each case will be April 30 at 2:30 p.m. Mr. Nelson, you wanted to speak as to bond?
Your Honor, if I may, I know that my client has a poor history of reporting to court. However, since our last time in court, I believe it was in September, she's completed square one inpatient drug treatment. Just looking at her physically, she looks a lot better today than she did back when I met her in September. So I truly believe that she's on the path. That doesn't mean she hasn't slipped up, that she hasn't had a couple relapses, but I think that she's certainly on the path to recovery. If the court would reinstate her personal bonds that were issued previously in this case, she understands that if she did not show at the time of the sentencing, that would reflect negatively on her, to say the least. So we are in the process of defending a child custody matter. It would certainly help her case, and it would help me preparing for that matter if she was out on bond, so that she can come to my office and help me prepare for that. So I am requesting that the court reinstate the personal bond that it had issued for her on both of these matters.
Your Honor, we would object to the reinstatement of bond. We've been trying to get these matters situated since last July. Defendant was offered treatment in lieu, did not show up for that. With regard to these particular cases, she was out on a warrant for one when she picked up the second set of charges, Your Honor. We would object.
All right, where you been since November?
Well, I went to square one, and then after that, I did go to the probation. I got COVID, and then after COVID, when she rescheduled to a different date, that was when I missed it. But I wanted to make sure I went to my son's court first before.
Okay. What'd you do at square one?
I completed it.
When?
What did you do?
When?
It's on the paperwork. October, right? Yeah, October.
Where do you live?
I live in Willoughby, off of Euclid Ave, so 37223 Euclid Ave.
And who do you live with there?
My mom lives there. I live there. That's where my child was subsiding, but now he's with his father until we can get this all taken care of.
Where's your custody hearing?
Out here in juvenile.
All right, what I'm going to do is I'm going to reset your bond. I'm going to release you on each case on your own recognizance. You're going to sign some paperwork, but what that in essence means, if you don't show up if you don't show up at probation and then at your hearing, then in addition to dire consequences here, you're going to pick up another felony 4 charge on each case. You understand that?
Yeah.
So you are to, I'm going to release you on your own recognizance.
Thank you, Judge.
And you're going to meet with probation. You're also going to be subject to being called in for a random urine screen.
Okay.
If you don't show up at that, your bond will be revoked and you'll spend the time in jail until the sentencing. You understand that?
Yes.
Anything else, Mr. Tavanche?
Nothing from the state, Your Honor.
Mr. Nelson?
Judge, the sentencing date was April the 30th. I just didn't catch the time.
2:30.
Thank you, Judge. I appreciate it.
All right.